To national news now, former President Donald Trump has been criminally indicted again. Late last night, a Fulton County grand jury charged the former president with 13 counts, including racketeering and conspiracy. In the 98-page indictment, 41 charges against Trump and 18 of his allies, including his former chief of staff Mark Meadows and attorney Rudy Giuliani. This is the fourth set of criminal charges the former president faces. All of the defendants now have 10 days to surrender voluntarily. Russ Mitchell and former federal prosecutor and Case Western Reserve University law professor Kevin McMunigal join us now to break down these charges. Russ?
Isabel, thank you so much. Professor McMunigal, how are you today?
Hi, Russ. Nice to see you.
Nice to see you as well. Let's talk about this Georgia case. There are some legal scholars out there who are saying this is the biggest threat. This case poses the biggest threat to the former president's freedom. Do you agree with that?
I do. I actually think several of the cases are very strong. But this RICO case, it carries a mandatory minimum 5 years in jail. So if he's convicted on the RICO count, the judge has no discretion. He has to serve at least 5 years in jail. So that makes it quite a serious threat. There's no discretion. And also that makes it a very powerful bargaining chip in negotiations. A lot of times with a mandatory minimum like that, the prosecutor might say, well, look, if you plead to something else, I'll drop the mandatory minimum.
I understand also, but I also understand, Professor, because this is a state case, he cannot be pardoned by anyone, including the governor of the state or a president, even himself, if he is reelected. Is that correct?
That's right. Under the state cases, New York and Georgia, he cannot pardon. So that's important. They're outside his reach.
Let me get your expert input on a question that I know a lot of people are asking. There are 19 defendants in this case. The DA, Fani Willis, says she wants to try all of these folks together, and she wants to do it within 6 months. As a former federal prosecutor, how likely is that?
Well, I think that there's a good likelihood that some of these people will plead guilty. I think she's got the case so well prepared. I think it could go to trial in 6 months.
Wow. What would that look like with all those defendants in the room? Even if some of them plead down, say there are 9 or 10 defendants in that room, what would that courtroom look like? What would the case look like?
Basically, it's up to the prosecutors to keep it from being a mess. When I was just starting out, the U.S. Attorney's Office in the Northern District of California filed a RICO case against the Hells Angels motorcycle club and had 8 or 9 defendants in a room at the same time. And that resulted in some convictions, but some mistrials too, because there were so many people involved, the jury was getting confused about what was going on. So having this many defendants, it's easy for the jury to lose track of what's going on.
Yeah.
So it can be a lot to handle in terms of just keeping things in order and allowing the jury to follow along what's going on.
In looking at the timetable, Professor, of what's to come here, the former president has 7 different court cases coming up. Now, some of the dates have not been set. Some could change, of course, but we're talking about 7 different court cases right now in the next year or so. Have you ever seen anything like this with any defendant? And if you're a lawyer, if you're a defendant's lawyer in this case, how do you handle all these cases coming at you?
Yeah, this is incredibly unusual. I sometimes had cases where I would have somebody charged in state court and in federal court, and normally one or the other would delay the charge until the other case was wrapped up, and so you do them one at a time, seriatim. Here, everything's going at the same time, and so and there's no automatic way to force the judges to coordinate. So that's going to be a little chaotic about trying to figure out which judge wants to go first and which will go first, and what happens if he's in the middle of one trial when they want to start the other trial. Yeah, it's really unprecedented.
It sounds like it's going to get rather sticky, as you say, to say the least. The former president's attorneys have indicated that they would like to move this Georgia case to a federal court. Takes it out of Fulton County, gives them other advantages in their mind. Do you see that happening in any case?
No.
No, not at all.
Absolutely not. No. Federal courts have plenty of stuff to do on their own, and yeah, state criminal cases don't get tried in federal court.
Let me ask you now a quick question as we leave you about the federal case involving the former president alleging election interference. Judge Tanya Chutkan warned the defense against what she called making inflammatory statements or attacks against anyone involved in that case. The former president seems to be testing that, going on his social media platform, calling her highly partisan and very biased and unfair. What are the potential consequences if the judge decides that the former president is violating that directive?
Well, you may remember the Roger Stone case. He posted a picture of the judge in the crosshairs of a gun, and nothing really happened to him on that. But Trump here could be charged with witness intimidation. You definitely can make a threat on social media. There are cases where someone makes a statement on social media, and there's an actual federal offense of making a threatening communication using interstate means of communication. So I don't think they're going to need that, though. They've got him surrounded on all four sides by all sorts of other charges. So the witness intimidation stuff, I don't see that as playing a huge role. The judge could hold him in contempt.
Yeah. Lots to see. Yeah, well, let me ask you, how likely is that a judge is going to put a former president in jail for a contempt charge?
Not very likely.
Yeah.
Although, if he repeats it, she may think that's the only thing that will calm him down, and so she might.
Wow.
I mean, the judge is going to be want to make clear that she's treating him just like anybody else, and any other defendant who repeatedly did that and violated orders would be held in contempt.
Understand.
So,
yeah. Professor Kevin McMunigal, as always, it is great to have your insight. I'm sure we'll speak to you again soon. Again, thank you so much.